Just confirming, can you hear me and see me? This is Tom.
Yes, I can.
Thank you.
Good morning, Harriet. Can you hear me?
I can hear you and see you.
Okay, great. Whoever is there. Is that who's running the hearing?
It's Casey.
Casey, hi. Good to see you.
Good to see you.
This time my camera works, so that's good news. Thanks.
All right, Harriet, can you hear me?
Yes,
You're not Harriet, Mr. Dixon.
close enough. I figured you want an answer.
I care more about Harriet. I care about
Thank
Harriet.
you. I'm still having those microphone problems, but I took out my headphones, so.
Okay, you're good? All right. We shall go on the record with proceeding number 24R-0168EG in the matter of the proposed amendments to the Commission's rules regulating electric utilities for a Code of Colorado Regulations 723-3 and its rules regulating gas utilities for Code of Colorado Regulations 723-4 to implement certain provisions in Senate Bill 23-291 addressing tariff filings, rate trend reports, cost prohibited from rates, and base rate proceedings. Administrative Law Judge Robert Garvey. Today is the 19th of November, 2024, at approximately 11:31 a.m. And this proceeding comes on pursuant to decision number R24-0804-I. And it's a continuation of the rulemaking proceeding that was continued a couple months ago. Again, I'll just be taking comments that we have here. I might have questions for people as they come up. We'll address many of the same subjects, I'm guessing. Again, I'll realize I have seen the comments that have come in after this decision was issued, including the ones today from the Energy and Policy Institute and also Public Services comments that came in yesterday. So I have seen those. You can go through those again. There'll be the opportunity after this hearing to file more comments if you wish. At the end of the hearing today, I'll decide whether we're going to continue or if we're going to end here, and the recommended decision will come out after that. I will ask.
Guys, Garvey, could you hold on a second so I could put my back in, and then I don't want to hurt my dog.
Okay. Don't hurt your dog, Harry.
Really sorry.
It's all right. Give me the heads up, Harriet, when you're ready.
My headphones out, then I can't hear me. All right.
Yeah, I can hear you. I can hear you.
I'm putting them in, and then it'll give me 1 second because they're not working. The speaker part doesn't work for some reason. So
Okay. You tell me when you're ready.
I'm ready because when I put them in, the speaker stops working. I mean, the hearing, the microphone stops working. So
All right.
go now.
You ready?
Yes.
All right. I'm not quite sure where I was. We'll go back on the record. I'm not quite sure where I was, but the procedures we'll use will be similar. Mr. Stoffel has already got it. Just if you'd raise your hand. I guess that's not in your hand, Mr. Stoffel. I learned this lesson from last time. Got to keep my cursor away from there. But if raise your hand, I'll call on you. You can speak. Please, when I call on you to speak, spell your last name and say who you're representing so Harriet can get that down and we can have a clear record of the proceedings here today. So with that, I will just leave it open right now for anyone who would like to speak. All right, see Mr. Piquet. How you doing?
I'm doing well. How are you? Can you hear me okay?
I can hear you fine. Good to see you, sir. I haven't seen you for many years, I believe.
It's been a couple of years. Yeah, great to
Yeah.
see you. I have just some brief opening comments, if you'd like to hear those.
Absolutely.
Judge Garvey, before moving on to other comments.
Mhm.
Great. Well, good morning, everyone. I'm Jason Piquet. I'm the Director of Regulatory Administration for Public Service Company here in Colorado. We appreciate your time and everyone else's time here today, focusing on how to best adopt rate filing and rate trend report rules for utilities and the Commission to adhere to. Yesterday, as you noted, we filed relatively brief comments on the modified proposed rules issued the other week, and the company is very encouraged by the further streamlining of the proposed rules. We think this will really help the efficiency and generally putting forward reasonably crafted requirements to make sure we can expeditiously move through the certification and review process for filings. In particular, very encouraged, as I just said, about the streamlining of certification, the removal of the original procedural schedule and discovery, technical conference, and forecasted information rules. We think this can make sure all parties spend time preparing as well as reacting to filings and a targeted list of requirements therein. As indicated in our written comments yesterday, Public Service still requests modification or clarification on a few last remaining items in the rules. And these generally pertain to rate trend reports that accompany any filing that would increase a rate or charge, and the need to focus them a little bit more narrowly, given the potential for large administrative burdens, given how it's currently crafted. And additionally, the certification process and how the Commission would sort through any protests, costs, prohibited from rates, and filing formats for certain materials. So that's all I wanted to flag here this morning. Please know that we have a few additional experts here in the room joining me from our regulatory team, including Steve Berman and Jeff Knighton, as well as Arthur Freitas from our our revenue requirements team, as well as a few of our legal friends with Tana Samar Pacheco and Steve Denman. So we're happy to answer any questions you have now or throughout our conversation here. And thank you for having this hearing and further discussion.
Yeah, thank you, Mr. Piquet. I appreciate that. I will make one mention real quickly. You brought up the fact that the removal of some of the rules that pertain to technical conferences and procedural schedules and stuff like that. I think my feeling, at least on those for right now, is that all rate cases are not the same. And there's nothing that prohibits parties from engaging in some of those things, but to require it, I just think it could in some cases create more costs. So just as a little more explanation on that. But thank you, Mr. Piquet. Hang out, do as you wish. I do appreciate your comment here today.
Thank you.
Okay, Mr. Dixon, I see your hand up.
Yes, thank you, Your Honor. My name is Tom Dixon. I am here on behalf of the Utility Consumer Advocate, and also present with me today is Joseph Pereira, P-E-R-E-I-R-A. Sorry. My last name is spelled D-I-X-O-N. We have filed comments, and I'm not going to repeat them at this time. We got them in on Friday, and I forwarded them to all parties that was aware of in this proceeding, so they could review them. We have taken issue with the removal of the procedural rules that you took out, and have so noted that. We have also, instead of simply challenging the rules as you removed, we went back and looked at the rules that were provided by the joint utilities and took their version of that particular rule and basically accepted a lot of their changes and also rejected their changes that removed comments from the public utilities holding company. So we have set for you a red line version, but what we've reinserted are in capitals, so it's clear what's new. It'd be nice to just do a clean set, but at this point, I think you need to have the full red line version from the companies as well as us. So I have no intention of addressing those comments that we've already written. I'm sure you'll read them or have already read them. With respect to the second set of comments that was filed by Public Service, we simply respond, we don't think that the rate trend report is by statute limited to only residential or the largest class of customers. We think it's broader than that. We know CEC has raised this issue as well, and we take issue with that. I'm intrigued a little bit by the company's argument that apparently, regardless of the completeness process, that is the certification of completeness process, that section 40-6111 subsection 1 nonetheless limits the time the commission can work on this case from 250 days from the date of the proposed effective date. And I note that's a statutory issue. Yeah, obviously, we can maybe talk about that in later rules, but we think that we hear what the company's saying, and we'll consider that after we've had an opportunity to review. Also, we take issue with the Public Service's suggestion that protests on completeness should be limited to the staff or to the UCA. While we appreciate that they think we will take that issue on and likely would, there are other parties in these proceedings that would also have an issue. Particularly, for example, the Colorado energy consumers are very active in proceedings such as this, and it would not surprise me they would file a protest on completeness, not to mention environmental groups and the like. So I just think limiting it to the two of us, while it's flattering that the trial staff and the UCA would probably address all issues and be the only ones to do, we think it's inappropriate to limit that in any fashion. We also feel that I think it's appropriate probably for us to indicate alleged deficiencies. We don't take issue with that. It makes little sense to say it's incomplete and not explain why. However, the 10-day time period that's provided, again, is shortened and unnecessary. I think here the issue being that when protests are filed by people other than the UCA and the trial staff who are interveners as a matter of right, although apparently we have to be acknowledged to be formally a party in the case based on a ruling by Judge Denman, who is now a participant in this case on behalf of Public Service. Nonetheless, we feel parties should have time to, if they're particularly likely permissive interveners, 10 days is an inadequate period of time. So we take issue with that. And I think from that perspective, we pretty much addressed the issues that were raised in Public Service's second set of comments. Thank you.
Okay. Mr. Dixon, I'll say real quickly. I didn't mention your comments at the beginning because yours were filed last week. So I did look at yours too. I just wanted to mention Public Services. They came in last night and Energy Policy Institute, because they came in probably about 20 minutes ago. So
Right.
So please don't think I didn't read your comments and only read theirs.
I did not take that assumption. We sent them out Friday at the end of the day. We're grateful if you had time to look at them.
No,
Thank you.
I have. Thank you. No problem. And also take a compliment when you get one. Come on, take that, Mr. Dixon. And I think we do have to acknowledge that your presence. I think I've acknowledged staff and UCA and the OCC in those days every time they've intervened, I think. But that's good. Thank you very much, Mr. Dixon. But overall, in your comments, I do appreciate that. I'll look at.
Let me make one other comment, Your Honor. I do have a hard stop at 1:15. I have the joy of driving down to Canyon City for a 4 o'clock hearing before the commission. So at 1:15, I will depart. However, as you can see on the screen right now, Mr. Pereira is the Deputy Director of the Utility Consumer Advocate. He may have comments that he will provide over and above what I've just presented. And should I be gone after 1:15, he will cover the hearing.
Fantastic. I appreciate that, Mr. Dixon. Mr. Pereira, I know you talked last time at the first hearing that we had. So is that a Black Hills public hearing that you're going to?
Yes, indeed.
Oh boy.
We went to one of them in Pueblo, and we're going down to Canyon City to hear the comments from the public.
That'll be how long was it scheduled for?
It's scheduled to go from 4 o'clock to 7 o'clock. And when we were in Pueblo for several sets of hearings, basically there were a number of recesses taken, but the commission stayed the full time and to give people an opportunity to comment. So I expect it'll run from 4 through 7 as projected.
I would bet it will. Okay, well, safe trip down there. So
thank you.
Okay, Mr. Pereira, you're on camera still. Do you have anything you want to add to what Mr. Dixon said there?
Nothing long right now, Your Honor. I would just note we added additional comment related to investor relations expenses, political expenses, and organizational dues in our comments using Commission Decision C24-0778 as guidance for those comments.
Yeah, and that's I mean I had a feeling that'll come up, and I'll just kind of address that real quickly. It's an open case, so it's kind of hard for me to say anything about that, and I don't really want to get too much into that. And there's too much interplay between the two.
Understood. I just wanted to make that note, and if you do have questions, we're available to answer those.
Yeah, no, I appreciate that, and I just want to make that comment too before before I get a 20-minute lecture about that case. I can't really do a whole lot or talk about it since it's an open case. So, all right, Mr. Pereira, thank you very much for that. And you can hang out. I'm looking for anyone else who might have any comments. All right. Oh, Mr. Sopkin, you didn't raise your hand, Mr. Sopkin, and Ms. Roach raised her hand, so she will go first. She followed the rules.
Okay. Okay.
Ms. Roach, if you could just go right ahead. Identify yourself.
Okay.
Tell me who you're with.
Thank you, Your Honor. So my name is Christine Roach. I'm here on behalf of Colorado Energy Consumers, or the CEC. I'm an attorney at Holland and Hart. And CEC is supportive of the proposed rules as they've currently been revised, and we wish to express gratitude to the Commission for adopting many of the blue line edits that we filed in earlier rounds of this proceeding. We would like to respond to public services comments filed yesterday. First, we have an area of agreement with public service, and that's their subsection D on page 11, that PDFs of executables are not particularly useful to just about anybody. But we would add to that request that because the PDFs are not useful and that's the only file format currently supported by the Commission's website, we would renew our request that Rule 3352 be amended in some form, just to clarify that regardless of intervention being granted, that any party that requests a copy of those executables from the company should be provided with those so that they can be reviewed and analyzed prior to filing an intervention. That won't be necessary probably in the future if the Commission's new filing situation changes to support executables, but for right now, with the goal of this, these rules to be adding efficiency to rate making proceedings, we think it's important that parties be able to review the executable files with some degree of haste. So if we could potentially request some sort of revision that would allow, or that would clarify that any of the utilities need to serve those when they're requested so that they can be reviewed. If they're part of the filing, I would think the public should have access to them.
Okay.
Thank you. So we also want to respond to public services insistence on limiting the rate trend reporting. As Mr. Dixon alluded to, we share concerns between CEC and UCA about the permissibility of limiting those rate trend reports in any way. The members of CEC are non-residential energy consumers taking transmission level service. And for public service to allege that residential rate trend reports would be, quote, generally indicative of the rate trends for other classes is just untrue. The energy transition is heavily focused on distribution level infrastructure and distribution level sales. So the transportation electrification plan, distribution system planning, those are just two examples. Those costs should not impact transmission level customers because of the principles of cost causation. So large customers' costs at the transmission level would vary substantially from residential or other distribution level customers, but they also vary substantially from one to another. So for public service to allege that using residential rate trends would allow parties in a rate case to make sort of an apples to apples comparison for other classes isn't really correct. When it comes to comparing residential customers to transmission level customers, it's not even an apples to oranges comparison. It's really more like comparing an apple to a fruit basket because there's so many changes to how residential and a large transmission level customer would operate. So the comparison just isn't going to work. Furthermore, for public services, additional FTE that they explain is going to be necessary with the expansive rate trend reporting. The FTE would be fully recoverable if found to be prudent in a rate case. And the members of CEC who spend millions of dollars every year on electric service are happy to pay their share of the $100,000 salary to have the benefit of rate reporting for our class. Public service is proposing over the next couple of years like $19 billion in spending in new infrastructure. And from our position, the least that the company can do is add an additional person to create reporting that will demonstrate to all classes of ratepayers how those requests are beneficial to those classes specifically. And lastly, public policy arguments aside, the commission just cannot grant public services requests to limit the rate trend reporting to a single class because that is in violation of the plain statutory language as we've outlined along with UCA in our previous comments. I'm happy to answer any questions you may have as well.
I like the fruit basket. I like that. I've never heard of apples to fruit basket. That's very good. I don't think I have any questions on that. I do appreciate your comments. And you can hang out if you want to. If there's anything else, something else comes up, please raise your hand if you want to come in again. Okay.
Thank you.
All right. Thank you. Mr. Sopkin, I believe you still haven't raised your hand, by the way. But there you go. Good enough.
Good morning, Your Honor. I have no fruit baskets for you today, but
I would be illegal. I couldn't take your fruit basket, I don't believe.
that's true. I'll be very brief. I'm here today on behalf of Black Hills Colorado Electric. Mr. Kochian is here today on behalf of Black Hills Colorado Gas. Just wanted to note for the record that we have read Public Service Company's filing that it made yesterday, and we are fully in support of that. And with regard to UCA's comments, we're still looking at them. Our basic point is, as we could see from the ongoing rate case, there are a lot of concerns about expenses, and to the extent we load on more and more requirements with regard to reporting, et cetera, while it may be Public Service Company just added FTE, as we could all see from this rate case, it's a little more complicated for us because we have fewer ratepayers to spread costs to. So we would just ask Your Honor to be mindful of that in your decision making.
No, I said
and maybe the easiest way to reduce costs would be to reduce the number of discovered requests, of which we have answered over 1,500 for this rate case.
Yeah, no, that's like I said at the beginning, they're taking out of the one part, the rules concerning technical conferences and so forth. I realize all rate cases are not made, it's not the same. All utilities are not the same, and that needs to be taken into consideration the best it can. In some cases, it can't. But I do appreciate that. Are you on your way to Canyon City too?
Other people from the company are on their way.
All right. Okay.
Yep.
Great. Well, thank you,
All
Mr. Sopkin. I appreciate that. And you hang out, and anything comes up, just raise your hand next time, please.
Thank you.
Okay. All right. Do we have anything else from anyone else? Mr. Pereira.
Thank you, Your Honor. I didn't think I would pop in this quick, but I think it worthwhile to just comment briefly on the idea of costs, especially related to reporting. To go, back to initial comments, parties like our office made the argument around some of these procedural issues and required filings that these are things that we ask for through discovery in every rate proceeding, it seems. And so many of those procedures and comments or procedures and requirements are repetitive pieces that are requested through discovery on a regular basis in rates. And so I think it's important for Your Honor to keep that in mind. And so there is some efficiency in that. In addition, it avoids issues around motion to compel and whether completeness related to discovery is an issue in these cases. Frankly, it seems that often in almost every case from the UCA's perspective, there could be an argument for a motion to compel related to discovery on some of these issues. And oftentimes because of the procedural burden related to that, it's just, oh, forget it, we'll move on with our case. And so so it's our thought that these procedures help kind of the completeness of the record. And yes, there may be costs related to this, but also, the UCA's perspective is, and I think I heard this from CEC as well, is that in almost every case, almost all the parties come to ratepayers asking for a new thing. And so in this case, ratepayers are coming back and saying, we feel these costs are justified relative to completing the case and allowing us to do proper analysis. And so hopefully that adds to your understanding of some of our thinking on this side and why we feel like these processes and reporting requirements are important.
Okay, thank you. No, I appreciate that. And I realize there's some things that are in every case, and like I say, it's a balance. It's trying to get a balance when the overall goal is to reduce the rate case costs. It's the balance that I'm trying to strike.
Understood.
So, Mr. Pomerantz, I thought I saw your hand up real quickly.
Yes, Your Honor, although I'm having a bit of blurring problems here.
You're incognito today. There you go.
All right. Thank you. First I want to thank you for reading our comments and apologize for getting them in so close to the start of the hearing. I wasn't expecting you to take a look at those with 15 minutes to spare, but we do appreciate it.
That's my fault. That's my fault for the late. There's a lot of stuff that's been going on. The commission's been very busy and trying to find stuff. So that's my fault. I do appreciate you getting them in.
Well, thank you. I will be very brief because I think the thrust of our comments does concern, in terms of new content, the decision that you referenced, C24-0778. So I won't make you respond to that. I guess, without getting into detail on that, I would say, Judge Garvey, you asked in the June 3rd hearing about sort of specific examples of costs and benefits from reporting. We, in our various comments, have tried to give evidence of the potential benefits of more robust annual reports from the utilities. I think we gave pretty credible evidence of how the reports that they're currently providing are not robust enough to ensure compliance with the law. I think the decision in C24-0778 sort of further validates those critiques and offers really clear evidence of how customers can benefit from consistent, evenly applied annual reporting that is not dependent on each rate case, which is our read of what is required by the statute. So I know that's getting into territory you've asked us, or you said you won't get into, so I will leave it there, but otherwise I'm certainly available for any questions that you have that don't touch on that proceeding, and otherwise appreciate your taking a look at our comments.
No, and thank you, Mr. Pomerantz, both for the initial comments that you did after the first hearing and the ones today. They're very insightful, very helpful. And I think that case, and the only thing I'll say about that case is you see kind of the dilemma that I have going in with two different things. I have to watch what I'm doing and always realize too that whatever I decide in this case is not the last shot. So I have to, and most policy things, the ALJs in general, we try not to touch on the policy issues. So and that's much as I want to say about that for right now. But I appreciate that. Appreciate you being here today. I appreciate everyone being here, and really, I would have rather had more notice for this, but I appreciate that. Thank you. Let's see if there's anyone else. Mr. Stoffel.
I get this to turn on. Let's see.
There you go.
We tipped in the afternoon. We are afternoon.
Yeah, right now. 12,
okay.
12.
Good afternoon.
Thank you.
So Nick Stoffel, STOFFEL, here on behalf of Atmos Energy. So I'll just reiterate what we heard earlier. Atmos really is in favor of the amended version of the rules that you proposed with your most recent decision. supportive of streamlining those and believe the procedural issues that have been discussed should be resolved in rate cases rather than codified in the commission's rules. Without getting into the substance of the decision in Piesco's gas rate case, as you'd like to avoid, I'll just say the view we take is that decision really highlights how a rate case where cost recovery is at issue is the appropriate forum to ensure compliance with the prohibition on recovery of certain costs, and that any reporting should flow from those proceedings, rather than requiring an in-depth review for a report, perhaps for a year where no cost recovery request was filed with the commission. And so I think similarly, that decision highlights how rate cases are the appropriate forum to vet and evaluate the reasonableness of rate case expenses, rather than just coming up with a rule that allocates responsibility without the context of the facts and circumstances of a particular case. So those are the few comments I had for you today. Happy to answer any questions. Otherwise, we'll plan to follow up with some written comments after today's hearing.
Written comments would be great. I appreciate them, Mr. Stoffel. I appreciate those comments very well. And I do see there's two sides of that's why it's really why I don't want to get into that decision right there.
Understood.
All right, looking around. Don't see anything else. Don't see any hands up. Mr. Piquet, did anything spark your interest since you were first?
Yeah, thanks, Judge Garvey. There was one comment, I believe, from CEC about actually two rather, about the publicly available executables. I think that her comment at the beginning there, I think, was spot on. To the extent that the commission's e-filing system or successor system, whatever that might be, and whenever that might come, seems to be the answer there. If there are challenges with executables getting converted to formats that are more difficult to read when accessed publicly by other parties that have not officially intervened or been granted intervention yet, that seems to be the right forum to fix that issue moving forward. I think we're going to stand by our previous comments that providing executables to parties that have not intervened is likely a step too far. So we'd look to that e-filing system as the solution there. And there was another comment raised by Ms. Roach, I believe, about the rate trend reports, and making the point that commercial or industrial impacts are very different than what the residential classes might be seeing in any given case or proposal. I certainly understand that point, and I think we would say that we show the bill impacts of any proposal as part of our filing upfront. To the extent that more full history included by a rate trend report could shed further light on that, I think that's an issue to be explored in a given case, and not be a requirement kind of set in stone in rate trend report rules. But I have my colleague here, Jeff Knighton from our pricing team, who's happy to talk about that more, including the administrative burden that it might add to open it up to commercial and industrial impacts.
All right, thank you, Mr. McKay. I think for sure, and you could probably know this as well, the likelihood of the commission getting a new computer system up and running in my lifetime is pretty darn small. No
comment on that, Your Honor.
I'll probably get in trouble for that. But all I know is that years before I left, we were talking about it, and I was gone for a few years, and I'm back, and we were still on the same system. So I wouldn't hold my breath on that one. I just do it based on what we got. But thank you again, Mr. Piquet. I appreciate you responding to some of the comments that you've heard. So, Mr. Knight, did you want to add anything, or are you just up there for me to ask questions?
Yeah, here if you have any questions. I agree with what Jason said about all that information being available in bill impact analyses and our filings. And then phase 2 rate case is, primarily about cost allocation and rate design, and there's ample information there about how it'll affect all rate classes. We're more concerned with the administrative burden of having to prepare and constantly maintain these 10-year histories of every single line item in our tariff, which would be a pretty big burden.
Okay, thank you. I appreciate that, Mr. Knight, and Mr. Piquet as well. All right. Mr. Davidson, how you doing, sir?
I'm doing well, Judge Garvey. It's good to see you again.
Good to see you.
I don't have really anything to add to your consideration today other than to, I guess, echo the comments that Mr. Stoffel made on behalf of Atmos. And I think that those comments are well taken. We did file comments in this proceeding earlier on. We didn't file any recent comments, but we may file some final written comments if that's your desire at the end of the proceeding. But I just wanted to say that we would support the approach that Atmos had presented in today and Mr. Stoffel's comments. So just to kind of round it out from the LDC side of things for you.
All right, Mr. Davis, I'm going to assume you're here for CNG. You didn't say that.
Oh, I should have said that first. You're right, Your Honor. Yes, I'm here for Colorado Natural Gas, and I appreciate you reminding me of that.
Well, I get in trouble from Harriet. Harriet would yell at me later if I did not make sure that I got that. And trust me, I don't need Harriet getting mad at me.
I agree with you. Thank you.
Thank you, Mr. Davidson. Good to see you again.
Same here.
All right. I'm looking for a hand. I don't see any hands. Okay. Well, I think most of the people that I expected would be here today have spoken and have filed comments. I don't think, and I do appreciate everyone's comment today. It's very helpful. I appreciate the written comments. I appreciate comments spoken here today. I'll still take comments. Thanksgiving's coming up, so I don't envision. First off, I don't envision we need another hearing. I'll close out the hearing today, and a recommended decision will follow. I'll still accept written comments if you get them to me fairly soon. With Thanksgiving coming up, and I have a couple other decisions that I'm writing, I don't expect the decision would be out in under 30 days. I think I'd be doing real good if I did that. But certainly if you get them to me within the next 2 to 3 weeks, that should be before any recommended decision comes out. And I'll leave it open one more time to see if there's anyone that would like to make any comments. Going once, going twice, and I don't see any. Again, I'd like to thank everyone for being here today. Please try and file your comments in the next 2 to 3 weeks, and I'll get a recommended decision out shortly thereafter. So thank you very much. We shall be in adjournment.
Thank you.